Missouri legislation. I could probably not offend everybody in the room, but if I don't offend some of you, by the time we're done, I probably didn't do a very good job. As Joe Beth was up here speaking, it kind of reminded me of how I got into a lot of the things that I do, and I know that most of you probably are familiar somewhat with my background, but 25 years ago in 1992, there was legislation passed in Jefferson City that established the Missouri Worker Safety Program, and that's a program I went to work for in 1992, so it's literally 25 years ago. And the division director would get called out on all sorts of speaking engagements and so forth, just like Kim Stilley, the regional administrator, was called. That's who is scheduled to speak today. And then at the last minute, something happens and the director couldn't make it, so they would call me up in Springfield and say, "Hey, Randall, the director can't make it. You're in Springfield. Would you go speak to the Ozark Rotary Club? Would you go speak to the Joplin Chamber of Commerce or the Branson Chamber of Commerce or whatever?" So I ended up, after a while, doing probably averaging at least 30 to 40 speaking engagements a year. And in the beginning, I tried to be as milquetoast as possible, needless to say. But the longer I worked with the Division of Work Comp, the quicker and the more I got involved in the legislative stuff. I got more involved in the Department of Labor. The Department of Labor is basically the Division of Employment Security, the Division of Work Comp, and the Division of Labor Standards. The Division of Labor Standards, ironically, is what Joe Beth was referring to, that has a consultation program. So with all that said, the reason I got so involved and the reason I started seeking out a lot of what was going on is because this was in the days before the internet. And I know we all take it for granted, but we all, especially anybody under 30, you can't even, well, shouldn't say under 30, but definitely under 20, you can barely remember not having the internet, not having email, and not having the ability to Google and look something up and getting instantaneous information. But in 1992, that instantaneous information simply did not exist. You were lucky if you found a 1-800 number. And so I started going into a lot of different arenas within the Department of Labor. That is one thing I did try to do, is stay within the Department of Labor, because when I would go out to speak, I mean, let's face it, I was the only person from the state that a lot of these folks would ever get to hear, and I loved taking questions because that meant I didn't have to put together as much of a presentation. You know, you can show up for 30 minutes and just wing it. Well, that turned into 30 minutes to 45 to an hour, and then I figured out real quick that, man, people really prefer to ask questions. They don't want to come in and see a slideshow of 250 slides. I only have 20 today, by the way. They want to be able to ask questions. So all that said, my presentation today is what's going on in Jeff City, what's coming out of Jeff City. I want you to ask questions. There are going to be some things we can zip through pretty quick, and then some things that we just simply don't know the answers to right now. And then back to that part about not offending anybody. I apologize if I do. Needless to say, Director Carl and Director Leap and Director Slusher. I'm trying to think any other directors of the Division of Work Comp that probably at one time got a phone call about, "Oh, Mr. Gammill said this, this, and this." I know one thing: don't ever offend doctors of osteopathic medicine. They will they will make lots of phone calls. But anyway, with all that said, we'll get into what we're doing here. The first thing I wanted to discuss is just simply the legislative process. How does it work? And I don't want to take us back to a government or civics class in high school, but just keeping in mind, state process is different than the federal process. In the state process, it's generally the same, but the biggest difference is, in the state process, is we have a part-time legislature. The legislature meets from January through May, so we have a part-time legislator, meets for about 4 months, and then they're over and done. They all go back to wherever they're from, and they have meetings, and they do different things throughout the year. But as far as actually having legislation coming out of Jeff City, it only happens basically January through May. Now, that does not mean that all the work is done in those 4 months. That simply means that the statutes start up here, and then they go to the department directors, and they come out and they're in rules and so forth. Those are the things that that's the old saying goes, where the rubber meets the road. A lot of the things that Joe Beth was discussing this morning with OSHA, those are all changes to the rules and processes and procedures that OSHA has decided to implement, but they're not things that necessarily came out of legislation that went through the Congress and Senate. So it's really important to keep that in mind. The House and Senate, they get together. A bill can start in the House or the bill can start in the Senate, and a lot of times you'll have parallel legislation where almost word for word, exact same thing is in the House and the Senate. We have 30 senators. We have 160 House of Representatives members. So anything could start on either side. There's not a lot of rhyme or reason to what actually finally comes out. But they get together. Once they get together and they, let's say it starts as a Senate bill. The Senate bill gets together. The Speaker of the House or the Speaker of the Senate will send it to a committee. The committee will review it. Usually the committees are 5, 6, 7 folks. They will review bills. If the committee thinks it's a good bill, they'll vote on it. They'll clean it up. They'll produce what they call committee substitutes. They'll change the legislation around, and then once it comes out of committee, it goes back to the full Senate or the full House. And then at that point, they will debate it, what they refer to as on the floor. When they debate it on the floor, they will eventually vote on it, up or down most of the time. They will vote on it one way or the other. And all of those things, just like this week, I was sitting, as I was putting together some final touches on my presentation here, you can click on a little audio file on the website and sit and listen to live debate. Now, needless to say, this week, it's never terribly riveting. It's usually, it's kind of like, as you can imagine, sitting in a government class in high school for 4 hours or 5 hours or 6 hours or whatever the case may be. But this week, they were talking about a prescription drug monitoring program. Missouri is one of the few states that does not have prescription drug monitoring, and there were 2 doctors that are both senators actually, and they were going back and forth all day long yesterday about pros and cons of Missouri passing legislation, enforcing legislation that said when you go to a pharmacy, you get entered into a database, and you can't go doctor shopping and pharmacy shopping and get all these different drugs. So that's just one example. We're not going to discuss that today, but that's just one of the examples that they were discussing just this week. Anytime something is finally truly agreed to and finally passed, that simply means that it's gone through both the Senate and the House. It can be truly agreed and sent over from the House to the Senate or the Senate to the House, and once both chambers have truly agreed and finally passed legislation, that's when it goes to the governor. Right now, in all honesty, there's only been about 5 pieces of legislation actually sent to the governor. He has signed all of them. The first one that he signed of any significance was the right-to-work legislation, as we all know is a big political topic back in the election season. But that was one of the first things he signed. We'll go into a little bit of that. The governor has until July 14th. Why they picked this particular date, I don't know. But July 14th to sign, veto, or do nothing. Doing nothing is actually something that the governors can do. Jay Nixon did it a couple of times on a couple of pieces of legislation where he didn't veto it, he didn't sign it. If you don't do anything, it simply goes into law. Most all new legislation takes effect on August 28th unless specified specifically in the legislation. Sometimes there will be emergency clauses, meaning it'll go into effect that day, the day that it's signed by the governor. Sometimes it'll go into effect on January 1st. But for all intents and purposes, most legislation takes effect on August 28th. Once it goes into effect on August 28th, or actually probably before that, as soon as the governor signs it, he will start sending it out to his department directors and their staff, and those folks will then work on the statutes to develop the details referred to as the rules or regulations. The CSR, the Code of State Regulations. CSR is available to the public. You go into the Department or the Secretary of State website, read it. That's kind of a little more devil in the details type thing. A perfect example is the program I worked for. The program I worked for had probably a couple of paragraphs of legislation, of statute that was passed by the House and Senate and signed by the governor. It was called House Bill 975. In 1992, House Bill 975 had 1 or 2 paragraphs that discussed the worker safety program, but the actual rules and regulations that said this is how the worker safety program is going to be implemented and how we're going to work and what we're going to do was about 25 pages. And so needless to say, that's where the rubber meets the road. The first thing that the governor, and this is just my opinion, the first thing, if you have a company, an employer, restaurant, manufacturing company, Walmart, it doesn't matter. The first thing that the owner is probably going to want to do is hire some managers. You know, if you buy a company, you get elected, you go and you buy this new company, the first thing on your agenda probably ought to be hiring some managers to help run your company. Governor Greitens was elected in November. Maybe he was really surprised, I don't know. Some of us were, good, bad, or indifferent, but needless to say, maybe he was really surprised, because most of the time when you're running for governor, not long after, even in November and December, and certainly by the time you're inaugurated in January, you're going to have picked your managers. You're going to be able to say, these are the people that I'm going to use to implement my policies and procedures and what I want done for the state, and those people are going to be put in place pretty darn quick. That hasn't happened. That hasn't happened. Why? I have no idea. Missouri, unlike the federal, let's face it, at the federal level, it's very, very political. We all know that. There's no doubt about that. There's people that get voted and confirmed, and we go back and forth, and they have all these big elaborate hearings and on and on and on. The state level's not really that, not quite like that. Usually if the governor appoints somebody, the Senate generally confirms them. I honestly can't think of any in the last several years where the governor suggested an appointee that the Senate would not confirm. And even if it happened, it was so off the radar that I don't even recall it. So with that said, one of the first people that the governor appointed, which the governor has 15 departments, so you got 15 managers. And 15 managers manage about 60,000 employees. So you kind of need those people. But 15 managers. One of the first people appointed was the Department of Insurance. Department of Insurance, the lady came from Tennessee. The Department of Health, I think that gentleman either came from North Carolina or South Carolina. If any of you in the room are certain, you're welcome to correct me, but he came from either North Carolina or South Carolina. The Department of Corrections, that lady came from North Carolina. And the fourth one, which is, as far as I know, only 4 people have been appointed. And again, correct me if any of you are aware of anything that's happened in the last week or so. But the fourth one was the director, Anna Hugh, with the Missouri Department of Labor and Industrial Relations. She will be she is the new Department of Labor and Industrial Relations director. And she was only appointed on March 30th. So she, as far as I know, probably hasn't, if she started at all, she's really, really new into it. She hasn't named any division directors, so none of the division directors have been appointed, but she has at least been appointed, so we're happy to see that. And she came from the state of Illinois. Governor Greitens, Donahue, has proven herself to be a fearless change agent, state and federal. We are honored to have her join us, shake up Jefferson City, and bring some much-needed reforms to the Missouri Department of Labor. And I would like to point out that it's actually called the Missouri Department of Labor and Industrial Relations. So that is what she is. She previously served as the acting director of the Illinois Department of Labor. That's what she was doing when she was hired to cross the Mississippi River, come over here and work for us. She previously served as the chief of staff to Elaine Chao at the Heritage Foundation. As many of you know, Elaine has also been in Washington in a couple of different roles. I think she was actually Department of Labor several years ago also. And she served as Associate Deputy Secretary of Labor for the U.S. Department of Labor, and she will be the first Asian American to hold a cabinet-level position in Missouri history. I thought that was very, very interesting. But needless to say, huge congrats to her. She does have a LinkedIn profile. You can go on her LinkedIn page, maybe get LinkedIn with her, send her an email, all this good stuff through the Department of Labor and Industrial Relations websites. Okay, within the Department of Labor, and again, the Department of Labor is going to be the only department we discuss today, because in reality, that's the only one that's 90% of what most employers have to deal with. But the Department of Labor has a Division of Employment Security. We have no one appointed. The gentleman that was there, I'm not sure if he's still showing up for work or not, but he just started last February, so he may or may not even be there. The Division of Labor Standards, that is the one that Joe Beth referred to. Joe Beth mentioned the OSHA consultation program where they can come out. They can help you implement OSHA requirements, OSHA programs, safety programs, training, things like that. That is actually a state program through the Division of Labor Standards. That person has not been appointed either, although a couple of previous Division of Labor directors still work within that program. So I know obviously they have some people who are qualified to do that within that, so they may get that person appointed pretty quickly. In that particular program, they're going to be charged with a very politically charged issue of prevailing wage, right to work. They enforce child labor laws. They provide OSHA consultation. They provide the mine and safety and health consultation. So they have a few little politically charged items on their agenda. So whoever does end up getting appointed there, they're probably, I assume, picking that person pretty, I don't know, conservatively, or hopefully they're taking their time and making sure of who we have. The Division of Work Comp, we don't have anybody appointed there either. So now that we've got a department director, hopefully we'll get the 3 division directors. Because the 3 division directors, let's face it, that's where the rubber meets the road. That's the ones, those are the people that influence everything that comes out of the Missouri Department of Labor and Industrial Relations. They influence, directly or indirectly, they influence prevailing wage, they influence the Missouri Commission on Human Rights, they influence workers' compensation, they definitely influence employment security, unemployment claims, whether or not you have to pay claims to somebody that quit showing, that, you know, you terminated for cause and things like that. All of those items are going to be coming out of those division directors. So it's extremely important that those people be appointed eventually. All right, also within the Department of Labor and Industrial Relations is the Labor Commission. The Labor Commission has 3 folks on it. The employee representative, the employer representative, and the Joe Q public representative. So we have 3 folks. Those are the people, if you don't like the employment security, they call them referees, but if you don't like the unemployment referee's decision on your unemployment claim, maybe they gave benefits and you disagreed with them and you want to appeal that, that goes to the Labor Commission. If you have a work comp judge that you know, they don't, and let's face it, who doesn't disagree with the work comp judges usually, but if you have a work comp claim you disagree with and you file that claim, that goes to the Labor Commission. The Labor Commission has had 2 members on it that I think both of their terms actually expired in 2014 and they weren't reappointed. So technically they are unappointed. And the only one that is appointed is the 3rd one, the public representative. And he was appointed by Governor Nixon, so needless to say, he's going to most likely not side with a lot of employer issues, probably side more often with the employee on the work comp, the unemployment, and things like that. However, the other 2 positions, which this is just the way Jeff City works. You have to have at least 1 person from each political party. All right. Typically, in the past, the employee representative has always come from the Democratic Party. That person usually comes from the labor unions in St. Louis and Kansas City. Let's face it, that's where they come from. That's what John Hickey, who was at the Division of Work Comp for 6 years, that's where he came from. He was a union pipe fitter, plumber in Jefferson or St. Louis. He ran for office, became a House of Representatives member. He was appointed to the Labor Commission. He was on the Labor Commission for about 10 years through 2 or 3 different governors. He was on the Labor Commission, and then he became the Division of Work Comp Director in 2011, but he is no longer there, needless to say. But he was the employee representative on the Labor Commission. The employer representative, as you can imagine, is most always someone that the Republicans, at the business, at the Chamber of Commerce, at Associated Industries of Missouri. That's usually their guy or their lady. That's the one they want. So we can start out, as you can imagine, we always have someone on the left, someone on the right, and then we have the public representative in the middle to duke it out with both of them. Well, interestingly enough, the public representative right now, again, was appointed by Nixon, so he's already a Democrat, obviously, and so the other two positions traditionally would be filled by one Democrat and one Republican, which would mean you're going to have two Democrats and one Republican on the commission. Needless to say, this may be the first year in a long, long time that the employee representative is actually going to be appointed as a Republican also. But considering what has and hasn't happened in the last 6 months, that's just a wild guess. But it's possible. Needless to say, the Labor Commission has not been very employer-friendly over the last several years. Work comp legislation from 2005 that supposedly had a lot of changes in it has been shot through with a whole bunch of holes. And in the real world, when I was with the Division of Work Comp, my office was actually across from the kitchen. So I got to listen to the judges talk about different decisions. They'd come in, make their lunch, we'd all sit around and BS, and I would ask them questions. I mean, they're good people. I like them. They're all very nice. As a matter of fact, my wife is actually still very good friends with a couple of them, and we see them on a fairly regular basis. But with all that said, the judges would converse back and forth about decisions a whole lot more informally with just them and me and the fence post about the way the way they looked at things. But here's the most important thing to keep in mind. The judge, first and foremost, the judge wants to render a decision that will make it past the Labor Commission. Or I shouldn't say make it pass. They want to render a decision that the Labor Commission will not overturn. You do not want to be the manager. We all work for a company where you have 3 or 4 managers. You have the CEO, the president, the owner, whatever, and then you have 3 or 4 managers, and you always have that 1 or 2 managers that are really doing all the work and running the show, and then you always have that 1 or 2 managers, or maybe just that one guy that you always kind of have to, do things opposite of what that one guy wants. Well, none of the judges want to be that guy. None of the judges want to have their decisions go to the Labor Commission and get overturned. So in reality, regardless of what a judge might actually feel, regardless of what a judge might actually want to rule, they're at the end of the day going to do what they think the Labor Commission will uphold. During the previous administration, actually going all the way back to Matt Blunt's administration, the Labor Commission ruled about 60% to 40% in favor of employers, about 60-40. That would be on all sorts of issues, work comp, unemployment, discrimination, whatever the prevailing wage, whatever the case may be. It's about 60-40 employer. During the Nixon administration, it actually reached about 80 to 85% for the employees. So it was a huge, huge swing. And a lot of people could argue that the previous administration was a little more middle of the road and the latter administration wasn't. But needless to say, that Labor Commission, those are the people we have got to watch for, because those are the people that the judges will rule the way they think the Labor Commission will uphold. All right, any questions so far? Any at all? I know you're either mesmerized or bored. I'm not sure which, but one way or the other, if you got questions, don't hesitate to ask. All right, boards, commissions, and task force. I think it's incredibly ironic, needless to say, that the governor would appoint a task force, which is a board of 12 people. They would appoint that to go through and say, we need to figure out who to get rid of on boards and commissions. It is a daunting task. As you see there at the bottom, there are currently over 1,200 unfilled appointments to boards and commissions in the state. There are a ton of boards and commissions with anywhere from probably 3 to 15 people on them that could be handling everything from waste disposal to soil to education to roads to the health, the environment, labor issues, employment issues, insurance issues, agriculture issues. The list goes on and on and on. You can even go to the governor's website. And in all seriousness, if you were interested, you can go to the governor's website or his Facebook page, preferably his website. There's a little drop-down box, and it says, apply for a board or commission. And you can click on that, and it'll go through all the list of the boards and commissions where those are available. And you can actually apply or appoint, or I shouldn't say appoint, but apply for one of those positions. I'm not sure how often they update that. I'm not sure how often they do plan on filling some of these, but considering we still have several department directors and division directors to appoint, I would suspect that's pretty low on the priority right now, but you can apply for those. The task force, the goal of the task force to evaluate the purpose and necessity of each existing board and commission, recommend a comprehensive executive and legislation reform proposals back to the governor no later than October 31st. The task force is comprised of 12 unpaid members. And by the way, most of these commissions are unpaid. The Labor Commission, those are 3 paid full-time commissioners, but most of these boards and commissions are unpaid positions, part-time, go to Jeff City once a month, once every quarter, once a year, whatever the case may be. The task force shall be co-chaired by the Lieutenant Governor, Director of Boards and Commissions, Governor's Policy Director, staff support by the Division of Professional Registration, which I think is bizarre because the Division of Professional Registration is one of the divisions within the Department of Insurance. But probably the reason they picked that one is that's one of the only 4 departments that have a director at this point. So with that said, that might be the reason, but I certainly don't know the tie between Boards and Commissions Task Force and the Division of Professional Registration. That's where the guys like insurance folks, barbers, salon stylists, anybody, a counselor, anybody that has a license or a professional registration has to go through the Division of Professional Registration to register whatever your profession is. And the task force shall be dissolved upon the submission of the recommendations to the governor's office on October 31st. So I think that's kind of interesting. It would be very interesting to see what comes out of that. All right, a couple of the things I wanted to do, obviously going forward, is to simply say what are the 3 or 4 or 5 biggest pieces of legislation that are likely to end up on the governor's desk. Because right now we've only had one of any significance to most employers, and that's the right to work. Right to work legislation was passed. It has been signed by the governor. It will go into effect. Basically, I think, and I'm not even going to try to remember that, but it goes into effect, I think, on January 1 of 2018. But it will go into effect. We'll discuss that in just a moment. But Senate bills of interest. Again, the Senate has 30 senators. There at the top, we have 544 bills have been filed. 39 have been perfected. What that simply means is 39 bills have gone all the way through the committee. The committee's back and forth with it. They sent it out to the Senate floor. They might have sent it back to committee, and they reworked it. They changed it. They added. They subtracted. They reworked it. They did this over and over and over, and then finally they agree and they vote on it, and it goes out of the Senate as a truly perfected bill. Once it's been perfected, it leaves the Senate and goes over the House. So right now, 39 bills, ballpark, have been affected or perfected as of April 12th, which was this Wednesday. And the only 4 of any significance I put up there that deal with a whole lot. Senate Bill 19, the Senator Brown creates new provisions of law relating to labor organizations. That's right to work. Not only has that one been perfected, it was sent to the House, it was moved out of the House, sent to the governor, it's signed into law. That's it. That's the only one. Senate Bill 43 modifies a law relating to unlawful discrimination. We're going to discuss that because there's 2 or 3 different bills that relate to discrimination and so forth. Senate Bill 66, Schatz. He is a senator out of the Union area of, I say Union, the town of Union. Union, Wildwood, southeast or southwest St. Louis. He's a pretty popular senator. He's been there for, I think, for 3 or 4 years. He's been fairly active. He owns Schatz Underground Cable. A lot of times when you're driving around, I see his trucks all the time. I've met with him as far as his insurance side and company and on and on and on because, again, I am a sales guy. But with that said, you'll see a lot of his companies, his trucks out putting in underground utilities. I just saw some of them yesterday in Nixa. So Schatz Underground, and they actually have a location in Nixa. That's what they do. They install underground utilities. But that's Dave Schatz. Dave Schatz has kind of picked up and run with the work comp as his primary focus for his time in the Senate. But Senate Bill 66 modifies provisions of law relating to workers' compensation. It's pretty broad work comp reform, and it's similar to 113, which is essentially doing the same thing. So 66 and 113, I tried to just kind of combine those together without going into too many details of each. But a lot of times you will have a Senate bill and a House bill that looks almost identical. The reason they look almost identical, for the sake of time, they get together, they say, hey, we want to do this and we want to do this, and so let's just put pushing these bills through at the same time on either side. But in addition, especially now, more often than not, it's legislation that was pushed through, truly perfected by the House, truly perfected by the Senate from 2014, 15, 16, from previous legislative sessions that was vetoed by the governor. Well, they come back and they're like, well, we all agreed on it 3 or 4 years ago. We don't want to change much about it. We might change a little. But in reality, let's just pull that old bill out that we passed in 2015, rubber stamp it from the House, rubber stamp it to the Senate, send it to the governor, expect him to sign it. Since Governor Nixon did veto a lot of legislation, there's a lot of that legislation that popped up real quick that you would think would be on the governor's desk already, but it isn't. So for whatever reason, it will be there. And in my opinion, all 4 of these bills will almost definitely be on the governor's desk. Senate Bill 19, the right to work. As we all know, this was a very politically charged issue back in the election cycle. That simply says if you're a union employer that you can't require every employee to be a member of the union in order to have a job there. This is something that Missouri did not forbid, but this legislation specifically says you cannot do that. Now, interesting enough, the legislation tells the employer, you can't do that. Under this act, employers are barred from requiring employees to become, remain, or refrain from becoming a member of a labor organization or pay dues or other charges required of labor organization members as a condition of employment. That's pretty much it. Any person who violates this would be a Class C misdemeanor. Moreover, the person's threatened violation, entitled to injunctive relief and certain other damages. Injunctive relief simply means that the court can say, stop doing that. Stop doing that. Which we found out this week that if United Airlines tells me to get off of a flight, I'm getting off of that flight, all right? So I don't know what happens when the government tells you to stop doing something. If it's anything like United Airlines, I'm going to stop doing that. That's called injunctive relief. The provisions of this act do not apply to any agreement between an employer and a labor organization entered into before the effective date of this act. That would be August 28th. So August 28th, any labor union agreement that a union employer has before that, if it requires everybody has to join the union to become an employee there, then that is still totally valid. That is still totally valid. However, after August 28th, it shall apply to any such agreement upon its renewal. And that, to me, is an important issue. Even upon the renewal of that labor agreement, even though it may not be a brand new labor agreement, it's just rubber stamped, it could be a renewal, extension, amendment, or modification in any respect after the effective date of this act. With that said, most of us are HR directors and managers, things like that. So one of the things that we're always consciously thinking, okay, I make this rule, I make this policy, what are some of the things how are the employee going to get around this one? How are they going to game this system? How are they going to get around this? What are they going to do to say, oh, I was at work, I was on time. Technically I crossed the plane of the parking lot at 8 o'clock, so I was on time. Didn't actually get in to clock in and at work until 8:15. Well, okay, so we got to say you're at your desk at 8, not you're on the property at 8. You're not on your way to work at 8. So there are simple things like that we as employers, when we write rules and regulations, we got to think, what do we really specifically mean that can be impacted? In my opinion, there's going to be a lot of union contracts that they're going to want to maybe even renegotiate before the end of this, before this goes into effect on August 28th. Because if I was a union steward, I'd probably want to say, hey, let's just, we've only got 6 months left. It comes up on January 1st anyway. Let's go ahead and negotiate it as of August 1st and renew it and make it a five-year term, 5-year agreement. Well, if that employer agrees to do that, which that's totally up to them, but if they end up working whatever out and they agree to do that, then quite frankly, that employer could continue for the next 5 years from August 1st, allowing or requiring people to join the union to get a job there. So clearly, that's an example of something, but that shall apply to any agreement upon its renewal, extension, amendment, or modification. So you're probably going to see a lot of these trying to get them taken care of before this goes into effect. All right, any questions on this? All right. Senate Bill 43, Missouri Human Rights Act. I didn't want to put JoBeth on the spot because I know there's no answer to this, but there's a lot of standards that you have to specifically identify before an employer and employee can even define what is discrimination, what is discriminating against employees because you require a drug test if they're injured on the job. That sounds simple. Trust me, things are simpler said than done. But with that said, what are the details? What are the details of that? What exactly is discrimination? The two things that we have, and if any of you have heard Jerry Harmison in Springfield, Jerry's a great guy, friend of the agency, has spoken to sessions before, and he always talks about the pie. You know, he used to steal the pie from his mom's kitchen and cut the pie, and might cut the pie in half, might cut the pie in 10 pieces, might eat 51% of the pie, might eat 49% of the pie. But in reality, we got two things that the Senate Bill 43 is trying to determine. What's the difference between motivating factor and contributing factor? Motivating and contributing. And as we can imagine, there's a huge difference. A motivating factor would be, in my opinion, just in my personal opinion, and I don't know that it's actually spelled out what motivating is. Maybe the courts have kind of defined somewhere along the way specifically what motivating is. Is motivating factor 60% of the reason? Is it 70%? Is it 80%? I think the argument is it's going to be at least 51% of the reason. So if your race, age, sex, handicap status, ethnicity, whatever the case may be, if that is 51% of the reason the employer discriminated against you, that would definitely be considered a motivating factor. However, what if it's 30 or 40 or 49? That's a little less clear. However, currently, we don't have the motivating factor standard. Currently, we have a contributing factor. So that's where it gets real murky. Contributing could be 5%, you know. Contributing could be 5 or 10% or 1%. Theoretically, it could be anything measurable is going to be a contributing factor. So somebody could sue their employer, and the employer could say 99% of the reason I fired Bob is because Bob wouldn't come to work and Bob is late, or Bob is harassing employees, or Bob wouldn't get off the plane when they asked him to in Chicago, or whatever the case may be. But Bob wasn't following company procedures, so we terminated Bob. Oh, and by the way, 1% is because Bob's old. Bob is over 40 and he's just slow and whatever. Now, is an employer ever going to say that? Well, I'd hope not. Sometimes I'm surprised what I read, but needless to say, that probably doesn't happen, but in theory, that's precisely what they're looking at. Currently, it's looked at to say, well, 1% of the reason, then you're going to be responsible for a discrimination claim, and you're going to be found, I hate to use the word guilty, but you're going to be found to have to monetarily compensate Bob for discriminating against Bob. That's the Human Rights Act. That's what they look at. They look at everything from pretty much anything and everything. I know all the HR directors are familiar with it, but they look at any type of discrimination in employment discrimination, And that is the thing that they try to figure out. Right now, again, they are currently under a contributing factor standard. They are trying to, Senate Bill 43 says we're going to move to a motivating factor. Exclusive remedy. I'm not sure how many. I honestly can't think of that many cases that leave the work comp arena and the Missouri Human Rights Commission and general employment law and end up out in some other court. But technically, this kind of narrows that down to say if it's any kind of employment issue, it cannot leave these courts. It cannot leave work comp if it's an injury. It cannot leave Missouri Human Rights if it's a discrimination issue. And it can't leave in general employment law chapter, which I actually looked for the general employment law chapter. I'm not exactly sure what they are specifically referring to, but the general employment law chapter within the state statutes. So they are saying this is exclusive. No more of these little oddball claims getting outside into some other court system. Filing of complaints with the commission, this is just kind of narrowing it down again to say you shall file a complaint if you're an employee you feel you've been discriminated against. You shall file a complaint as a proceeding to filing a civil action under the Missouri Human Rights Act. That simply means I know we're all familiar with it, but your right to sue letters. If you don't first, at least go to the Commission on Human Rights and see if they can figure out a solution and get your problem taken care of. Once you go there and they say, okay, we've tried to help, we've tried to get involved, we don't think you got a good case, or we do think you got a good case, but for whatever reason, we're just saying, hey, we're out of here. We're not going to be able to help you. And as you can imagine, this is going to be an employee situation where they go to the employee and they say, we're just not going to be able to help you. If we can't help you, you now have the right to go off into civil court and file a suit against your employer. They've issued your right to sue letter. A lot of employers see a right to sue letter as a bad thing, but in reality, that usually means that the employee doesn't have a very strong case, and the Commission on Human Rights isn't really going to get that involved in it. Failure to timely file may be raised as a complete defense by a respondent or defendant in the future. I think the key word there is complete defense. Complete defense. For example, in the past, and this happens with work comp also, unfortunately. Work comp, the statute is 2 years to file a claim. This is 180 days. The employee comes in at 185 days. The judge or the Commission on Human Rights could say, yeah, you, the employer, you were somewhat harmed. Yeah, you'd have been able to put together a better defense. Yeah, it didn't help a whole lot that the claim was filed late, but you can't use that as your only defense. You're going to have something else to go along with that. What this is saying is just the fact that it's not filed timely can be used as your complete defense. That and nothing else has to matter. If that is all you got, that can be your complete defense, and you can deny, or the Commission on Human Rights is going to say, we're not going to take this case up because it's over 180 days. All right, and then, so that's the Commission on Human Rights. That's Senate Bill 43. That one has again already been perfected in the Senate, headed off to the House. Continuing on a couple of other things there. This is interesting. The business judgment rule. I always liked the business judgment rule. I like to fall back on that when I'm at home. I call it the husband judgment rule. The husband judgment rule, or the dad judgment rule. But it's basically just a legal philosophy is saying that the directors of a corporation acted on an informed basis. They knew what was going on. They made a good faith judgment, and they were honest in their belief that the action they were taking was in the best interest of the company. Now, are we perfect? Is anybody perfect? Nobody's perfect, so we can't really hold people to a perfect standard. But within the business judgment rule, the jury has to be told by the judge, if this ends up in a civil action, they have to be told by the judge to keep in mind that you've got to make the assumption that the directors of the company acted in good faith with the best interest of the company in mind and on an informed basis, that they knew all the details, that they knew what was going on, they knew everything that was going on. So that's important. But that's basically rules, or that's something that the jury would be required to listen to, but it doesn't mean they're going to act on it any particular way. They could still ignore it. Relief discusses here a little bit about the relief, which, to be honest with you, I don't know what the current trends are. For example, the new under Senate Bill 43 here, they give you some specific, shall not exceed back pay and interest. Okay, you discriminate against somebody, you got to give them back pay and interest. And then on top of that, if you have 5 to 100 employees, you got to give them $50,000. That's got to be your $50,000. That's your settlement. If you got more employees, you got between 100 and 200, got to give them $100,000. And if you got 200 to 500, you got to give them $200,000. And if you've got more than 500 employees, you've got to give them $500,000. So it specifically spells out what the damages are in addition to back pay and interest on that back pay. Whistleblower protection. I thought that was interesting to find that one here. But they went ahead, there's not really anything in there specific that good, bad, or alarming, but it specifically spells out that the Whistleblower Protection Act employers are barred from discharging an employee of an employer who reports an unlawful act, who reports an employer's serious misconduct, refuses to carry out a directive issued by the employer if it would be a violation of law, and who engages in conduct otherwise protected by statute that doesn't have any other way for a private action, which is an area that employees just need protections, and they want protections for that. All right, Senate Bill 66. Again, I called this broad work comp because it's not real specific on any particular issue. And maximum medical improvement. Good Lord, we all thought that we knew what maximum medical improvement was. Maximum medical improvement is very simply this. If I cut my finger off, it's not going to grow back. That probably doesn't surprise any of you. It's not growing back. It's going to heal, and I'm going to be without a finger or a hand. There was a gentleman here injured several years ago, I say several, probably in the last 15, that cut his entire hand off, and he would go around to lots of different venues just like this, or employee training and so on and so forth, and show people the effects of not paying attention to safety and not working safely and maybe modifying guards or whatever caused him to cut his hand off, but he had his entire hand cut off. Needless to say, it's not growing back. When it heals up, once it heals up, it's as good as it's going to get. It's at maximum medical improvement. Who determines that? The doctor. The doctor should be the person that determines if you're going to continue improving. If you're going to continue improving, you're not at maximum medical improvement. If you've improved all you can, you know, my finger is healed as much as it's going to, the wound is healed, on and on and on, the stitches are out, whatever the case may be, that's as good as it's going to get. May not be what I want, but it's as good as it's going to get. This legislation more specifically defines it to say it's at the point which the injured employee's medical condition has stabilized and can no longer reasonably improve. I think a lot of the work comp cases in the past couple of years, the past probably 3 to 5 years, if you can imagine what's a benefit to an employee saying they haven't reached maximum medical improvement, well, the benefits, you're either going to have to continue paying them lost wages, you're going to have to keep them on light duty forever, you're going to have to let them go home or terminate them, and they sit home and draw that paycheck because they draw that check and they draw that amount of money until they reach maximum medical improvement. And this just simply says this is the way it's defined. And it was getting really cloudy as to when maximum medical improvement had actually stabilized and benefits could stop. Line of duty compensation. This is huge. This is huge to me because I look at it and I'm thinking I can see how judges are going to take that and move into a different area. The reason this is huge to me, line of duty compensation, current statute allows for $25,000 additional payment for death in the line of duty of basically firefighters, police officers, air ambulance drivers, several different folks that were specifically spelled out in the legislation. But here's what gets me, and this is what concerns me about it, if I got a pointer, is it says the bill also, it outlines a distribution process for that payment and provides survivorship to any designated party or adult children. Okay, work comp benefits traditionally have not had survivorship benefits. The reason being, what is work comp? Work comp is supposed to help you and help your family while you can't work. Well, after you die, you're probably not going to be working whether you were injured or not. So technically, the benefits were always supposed to end at death, and the death says you're not going to be able to work anyway, so why should the employer/insurance carrier continue paying your family benefits or pay your estate a benefit or pay your children a benefit after you die? Well, the only benefits that were allowed to be continued was a spouse that you were married to at the time or minor children. That was it. That was the only survivor benefits out there. What this specifically says is that even if you're one of these line of duty folks, you're killed in the line of duty, I have no kids, I have no spouse. Right now, Missouri, I have no dependents, so guess what? If I don't have any dependents, nobody gets any money. This says that you can designate whoever you designated on your life insurance, what life insurance they're talking about, I'm not sure, but whoever you designated on your life insurance can get that $25,000. And if you didn't designate anybody on your life insurance, then it can go to your children, even if they're adult children. So even if they're 30, 40, 50, 60 years old, we all have, I shouldn't say we all, but some of us probably have adult children that are, still on the dole, so to speak, still need some money from mom and dad, all that good stuff. But at the end of the day, you're not obligated to give them anything. Trust me, you can say no. You can say no. But this says that even adult children who are not dependents can still get this $25,000 benefit. Now, it specifically refers to this benefit. What would concern me is whether or not judges can start taking that in the future to say, well, these adult children and whoever you designated on your life insurance, they're not married, they're not your minor children, they should be able to get benefits, continue to getting benefits also. That to me would be problematic. All right. Additionally in this, we have S Corps. S Corps shareholders are 40% or more ownership may elect to reject coverage. Right now, Missouri, the only people who can say, hey, I don't want to cover myself, I want to just elect non-coverage are sole proprietors and partnerships with no more than 2 partners. Partnerships, LLCs, up to 2 people. Up to 2 people. Technically, it's what it says anyway. They can reject coverage. This is saying even though if you're a corporation, technically the corporation, I'm an employee of a corporation. Even if I'm the owner and I have 100% of the stock and I have 3 or 4, 10 employees, 100 employees, or no employees, whatever, I'm an employee of the corporation and the corporation cannot elect to reject coverage to cover me, the employee, even though I might be the 100% shareholder. Going forward with 113, if you have 40% or more, you can elect to reject coverage, just like the LLCs and just like the sole proprietors. Huge, huge, huge deal right here. Not because it's changing anything now, but as an insurance guy that writes work comp, we have, matter of fact, one of our producers wrote an account yesterday where the owner and 3 or 4 partners, I can't remember exactly how it all went down, they wanted to reject coverage. Well, as an agent, I'm obligated to tell you, and I'll speak real clearly so it's on a recording, you do not have any other coverage if you reject work comp and you have a work comp claim. If you have a work-related injury and you file that on your health insurance carrier is going to say, no, that's work-related, we're not paying it. When I worked for the state, there was a lady that worked there, and she worked for Blue Cross Blue Shield out of Kansas City at the time, way back in the day, and her department was a group of 8 people, and Blue Cross Blue Shield had 8 people that did nothing but review claims to try to determine if they were work comp or work related, and if they were, guess what? They're going to reject them. Now, a lot of business owners think, oh, I can make it work. I can slide it in there into my wife's health insurance or my husband's health insurance or my personal health insurance or my individual health plan, my Obamacare plan, whatever the case may be. That may be all fine and dandy. If you get sick, if you cut your finger off, because we've already determined it's not growing back and you don't have insurance, you don't have work comp because you rejected coverage, yeah, you might be able to skirt the system. What happens if it's 2 o'clock on a Wednesday afternoon and you're driving a company vehicle and you got a loaded gravel or rocks or boards or lumber or something like that, and you go through an intersection and some guy runs a red light and plows into you, and you're seriously injured and you're dirty and you got your work clothes on, obviously, and they grab you and they haul you off to the hospital, isn't it going to be pretty obvious at 2 o'clock in the afternoon? Or if you fall off a roof, or if you or fall into a trench, or if you cut your hand off in a machine, or you do something like that in the middle of the day, on a work day during the week, those serious injuries like that, I can almost guarantee you your insurance carrier are going to be able to determine that was work-related, and your health insurance is not going to cover that. So that's a big deal. Big deal. It already is a big deal, but in my opinion, it'll be an even bigger deal if people are allowed, if even more people are allowed to reject coverage. Drug penalties. This is another one. This one kind of coincided with what Joe Beth was discussing and our issues with OSHA and all that good stuff. It's telling us we can't drug test our employees, we can't have a blanket policy, on and on and on. But specifically, what this is saying, and currently we already have this. If the employee was using drugs in conjunction with the injury, you can reduce their benefits by up to 50%. Got to have a policy, got to have it enforced, all that good stuff. If the drugs likely caused the injury, then you can completely deny the claim. So we already have a conjunction requirement, or I should say a rule, an approximate cause rule. 50% if it's in conjunction, 100% completely deny if it's the proximate cause of the injury. They basically, as some of you know who have tried to take this and gone to the administrative law judge, they make you jump through a whole lot of hoops before you can say, well, this is really the cause or this is really the test, and the employee, they think it was wrong and you only tested them once. There weren't a lot of really black and white rigid testing parameters. And it might be a 5-panel, it might be a 500-panel. There were just so many loopholes, and every single judge could come up with their own different reason to deny you the ability to reduce a work comp claim benefits for drugs. So they are simply saying, we've got a positive test for non-prescribed controlled drugs at the time of the injury, that the injury was sustained in conjunction. That's key, in conjunction. The testing was administered within 24 hours. The accident notice was given to the employee. The test results within 14 calendar days. The employee was given an opportunity to perform a second test, and the initial or any subsequent testing which forms the basis of the presumption was confirmed by mass spectrometry using generally accepted medical or forensic testing procedures. So basically the statute now spells out this is a bona fide drug test. This is what a bona fide drug test and bona fide requirements that you, the employer, have to follow in order to be able to take this. It helps a lot. Otherwise, you are just kind of at the judge's whim. By the way, I see a lot of you writing. By all means, take notes, ask questions. We will post this on our website. I literally worked on this up until yesterday morning, and so Super Dave has left me, but Super Dave is here a moment ago. I didn't want to send this to him yesterday and say, hey, Dave, make 80 copies of this, and I didn't want to do that. He'd kill me. And I cannot outrun Dave, trust me. But with that said, I apologize for not having a written handout, but we will post this on our website. We can also email it to you, so you will have this. Or if you would like, you can go back to the Missouri General website or the governor's office. As the governor signs things, they are posted on his website. So if something's on his website, you don't even have to read about, 50 bills. 50 bills gets condensed down to one, and then the one ends up on the governor's desk and he signs that, that means you can forget about the other 49 because they don't matter. Well, if you go to the Missouri General website, you're going to have to somehow thumb through all 50 to figure out which ones do matter and which ones don't. That's what I've done for you here. That's what we've done here. In addition, on work comp, termination of the disability payments, an employee voluntarily separates from employment, and I know most of us, and even myself, are looking at this and thinking, isn't that the way it already is? Doesn't that already happen? But in reality, there have been several little cases fall through the cracks where the employer was required to continue paying benefits even after the employee voluntarily left. And so if an employee voluntarily separates from employment at a time when the employer has made work available for the employee quits. They leave, they abandon their job, they move, they decide they don't want to do your light duty job. Then specifically spelled out in the statute, it says, neither temporary total disability nor temporary partial disability benefits shall be payable to the employee. Again, this is one of the things that we as employers look at this and think, this just makes sense. If we've offered a light duty job and the employee doesn't want to take it, they don't have to take it. But we're not going to pay you benefits because you don't take it. Judges get real creative on ways to continue paying those benefits or requiring those benefits, and most of the time, unfortunately, it's a whole lot of back benefits. Is that what it actually ends up being? Because that doesn't happen and then get decided by the judge a week later. That's headbutting between you and the employee and the insurance carrier, and then it gets decided 2 years later, and the judge says, oh, well, by the way, you owe 2 years of back benefits. That's the way a lot of these end up being. So it's nice to see that specifically spelled out in the statute. Discharge and discrimination. This is the one that everybody's been talking about, the Templemeyer case. Now, if you do not have employment practice liability insurance, I just got to tell you, Connell Insurance can write you a policy for employment practices liability insurance. And we've offered it. If we haven't offered it, we're offering it now. Because employment practice liability insurance is an insurance policy that will cover you for this. Your work comp policy does not cover you for this work comp retaliation. Work comp policy, let me say that again, work comp retaliation. An employee says that you terminated them because they had a work comp claim, files a discrimination claim against you, and you're found to say, yep, they did, $300,000, judge says you have to pay it. Your work comp policy does not cover that. If you have an employment practices liability insurance policy, it does, at least all the policies I'm aware of, does cover that type of work comp retaliation, that type of claim. Now, I don't know if all of you have it. If you don't have it, you need to at least call us, ask, look at it, quote it. Quite frankly, it's usually about $50 to $100 per employee per year. So if you have 100 employees, your policy is going to be probably $5,000 or $10,000 per year. That's ballpark how it's priced. It's usually priced per employee depending on turnover, employee handbook, sometimes what industry you're in, things like that. If you don't have employment practices liability, the good news is you're not breaking any rules. It's a completely voluntary coverage. You do not have to have it, but so that means that some of you may or may not have it and so forth. But you do need it if you want coverage for this case. This is discharge and discrimination. The Templemeyer case has always, basically, the way the courts have ruled is to say that the work comp injury had to be the proximate cause of the injury, and they've kicked that around and tried and played around with it, yada, yada, yada. Well, interesting enough, if the work comp injury had to be the proximate cause, or the work comp event, I should say, the work-related event was a proximate cause for the injury, then they assumed that the work comp retaliation or the work comp claim had to be the proximate reason, or at least a significant reason, for the employer to discriminate against the employee for filing a work comp claim. However, I think this goes all the way back to 2012. I can't remember the precise date of the Templemeyer case, but the Templemeyer case found a judge that agreed, and this would have been outside the work comp system, by the way, that they found a judge that agreed that, hey, or maybe even a jury, that said, hey, the work comp was that 1% contributing. It wasn't 51%. It wasn't 20, 30, 40, 50. It was only a contributing factor to that employer terminating that employee. Well, I have no reason to doubt that most employers know that just because somebody has a work comp claim, you can't terminate them. But let's face it, just because somebody has a work comp claim doesn't mean they were your best employee either. Maybe you had a lot of other reasons to terminate them. You need to watch it really, really close right now, I can assure you, until this is passed on August 28th, and even if it goes into effect on August 28th and you terminate the employee on August 29th, trust me, you don't want to be the guinea pig case. So you might want to just sit on the sidelines before you start terminating any of these problematic people that have had work comp claims. But all that said, this specifically says that work comp basically modifies a provision to set no employer or agent shall discharge or discriminate against an employee when exercising such rights in the motivating factor in the discharge or discrimination. This goes back to basically what Senate Bill 43 was saying about discrimination in general. So this is the same standard as the Commission on Human Rights as we have now specifically for work comp. But that is big. There have been a lot of work comp retaliation claims that have been filed in the last 3 or 4 or 5 years that have been successful, that employers have had to start paying, and this is trying to fix that. All right, those are all the Senate bills. Those are all the Senate bills. We're going to go through real quickly on the House of Representatives. And on the House of Representative bills, back up real quick, just to remind us of what we had here. In the Senate, we have 30 senators. We've had about 544 bills filed. We've had 39 perfected and sent over to the House, so 544. Whereas on the House of Rep side, we have 160 legislators, 160 on that side, and we have had 1,200 bills filed. Needless to say, when I was going through, I'm like, wow. You know, I like you guys. I want to help you out, but I'm not reading 1,200 different legislative articles and bills. That's a pretty daunting task. So, needless to say, I thought, I'll take the easy way out. I'll go over and see what's been perfected, what's come out, what's been sent. Wow, I had no idea. They've had 144 bills perfected and sent over to the Senate. So it's like, wow, that's a lot of things to go through. But I went through every one of them. Now, some of them, I'll be frank with you, there are a lot of things out there going on that clearly impact business and business owners and us as employers. But for the fact that this is specifically dealing with human resources and work comp and just what we set our seminars up to be, I wanted to specifically deal with the ones that really impact us in the areas of unemployment, work comp, prevailing wage, things like that. So that's not to say that if I've only picked out 5, that's not to say the other 139 here aren't significant, but we could be here a long, long time and still not cover all of them. I'm going to give you the resources here at the end if you want to do a little research and find them. Okay, House Bill 95, collateral source rule. I like this one. When I read this one, because a lot of people I think weren't really sure, I got a call from someone who's not a client, by the way. Not a client. She was really irate at her attorney, and it's an employer in Springfield. They are self-insured on their health insurance, and they're self-insured on their work comp. They had an employee that filed a work comp claim, and I take that back. The employee filed a work comp claim. Well, yes, they did file a work comp claim. They were butting heads about whether it was a work comp claim. So the employers, they're like, okay, this might be work comp, but we're denying it as a work comp. We think this isn't work related. And so we started paying it. They paid all the bills, all the medical bills, paid everything, took care of everything under health insurance. Everything's paid. The employee's out no money. Let's assume it was a zero deductible. It might have been a $1,000 deductible. I don't really know. But for all intents and purposes, it was tens of thousands, if not hundreds of thousands of dollars in medical bills that the employer paid under their health insurance. The employee then goes to the judge and wins the employee's case, and the judge agrees it was indeed work comp. Well, the work comp bill, all the medical bills have already been paid. So who do you think gets the money for all of those medical bills? The employer's like, we've already paid them. That doesn't matter. We can't take into the fact that those bills have already been paid. The judge says the employees awarded all the medical bills. So it's called simply double dipping. Double dipping for medical bills, generally medical bills. Maybe there's some oddball things, and they talk about the value versus the actual cost and on and on and on within the legislation. Because needless to say, what we have here is some really, really, really condensed versions of all this legislation. But that is a collateral source rule. We're going to go into that just a little bit more. We also have a prevailing wage legislation. I saw Larry, there's Larry Stock. I read something the other day. Larry has an opinion on prevailing wage. One of those construction guys, you know how they all are, right? So Larry had a few items to mention about prevailing wage, but that's some legislation that is very likely to end up on the governor's desk, and that repeals Missouri's prevailing wage law currently required on public works projects. And then House Bill 288 and 289, both by Scott Fitzpatrick, which is actually a state legislator from the Shell Knob area, so he's kind of a local fellow. And he's got one on 288 with unemployment compensation. That's actually fairly simple. It just simply says we're going to set your number of weeks of compensation equal or in coordination with the actual unemployment rate. If unemployment rate's 3 or 4% and you can't find a job, then we're really questioning how hard you're looking for that job. In 289, he's got his work comp, and the only thing it covers is at 40%. And then Kohlmeyer, I brought this one up simply because I thought it was interesting. It's a business issue, not necessarily a human resources issue, but we'll discuss that one. So, collateral source rule. Special damages claimed by the plaintiff at trial that have been satisfied by a payment from a defendant, the defendant's insurer, or authorized representative prior to trial are not recoverable. The defendant is entitled to deduct such payments, i.e. the employer. I can say, hey, I've already paid that $80,000 in medical bills, so we want to deduct that toward the damages from any judgment that you, the work comp judge, are about to give me. Parties may introduce evidence of the actual cost rather than the value, so that's going to be a little bit of a gray area there, but it's going to be minor in comparison to an employer who has paid, or even the employer's insurance company. I use the example of that employer because they were self-insured on both. It just seemed to them to be especially egregious and wrong, but in reality, whether they were self-insured or not, the employee could have filed it on, Humana or Cox Health or Aetna or whatever the case may be, and got all those medical bills paid. Then later on, the judge says, okay, you get compensated for your lost time, your wages, your disability, and all your medical bills. So, oh, wait, the medical bills have been paid. Okay, we'll just add that to your check. This specifically says you don't just add that to the check. That gets taken off. No more double dipping. No more double dipping. How many of you probably thought that was a good idea to begin with? Probably none of you. That just doesn't seem like it should have been allowed to begin with, but it was allowed, and it was allowed specifically to an employer that literally called me just a few months ago. So when I saw this, needless to say, I sent it to her, and the chances are very, very strong that maybe her company had something to do, or her attorney had something to do with that, getting that changed. Anyway, prevailing wage. I could probably have Larry come up and talk all the rest of the morning about prevailing wage, but here's something about prevailing wage that when I was with the Department of Labor, and I'm going to just go a real general summary of how it works. If you're building a commercial project, it's not required to be a public works project. It's just any commercial project. And within Greene County, Stone County, any county, Texas County, Shannon County, whatever the case may be, if you're building a commercial project, you, the employer, you, the contractor, could fill out a prevailing wage report, even if you're not required to pay prevailing wage, but you're just on a commercial project. You fill out and you say, okay, I just built this $10 million project, and this is what I paid my employees. This is what I paid my plumbers and my electricians and my roofer, my concrete guys. This is what I paid everybody. This is how much their benefits are per dollar. So it might be I paid them $12 per hour, and their benefits were $3 an hour. And so I'm an employer. I know for a fact I hired employees in this county, in this area, and this is what I paid them. We had a good project. Everything went fine. They fill that report out, and they send that report to Jefferson City. Well, theoretically, Jefferson City would get reports like that by the thousands or hundreds at least. But they would get all those reports, and then they would go through, combine them all together. That's in that Division of Labor Standards, by the way, that I was mentioning. The Division of Labor Standards would combine them all together, and then they would be able to go to any county in Missouri and simply say, okay, how much does a plumber on a commercial project make? How much does an electrician make? How much does a concrete guy make? How much does a roofer make? And so forth. In reality, the union contractors or the unions and their attorneys, they might be the one guy that filled out the report, and believe me, the guys with the higher wages would always fill out the report because they would want to fill out the report to say in Shannon County, I had to pay my guys $35 an hour plus $15 for benefits, so I had to pay $50 an hour. But if you had a whole bunch of others that paid a lot less, the prevailing wage for that county might be set a lot lower. So the folks out of St. Louis or Kansas City and the unions, they would go to the Division of Labor Standards, and they'd say, oh, yeah, you got 40 reports, and that's great. You got all these 40 reports, but, oh, this one didn't do this, and this one didn't dot an I, and this one didn't cross a T. This one's, kind of illegible, so we're going to throw this one and 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 this one out. So we'd end up throwing out 39, and who do you think's left? The one guy that's paying $50 an hour. So they would always get everybody's thrown out except for the highest one. So then all the counties and cities and a lot of contractors, needless to say, were always coming and saying, I do a lot of work in this county. That is not the prevailing wage. That prevailing wage rate is exaggerated. That's inflated. In the counties and cities, public works, when they go to build a bridge, a road, a building, university, Missouri State University, whatever the case may be, if it's any kind of public entity and they go to build a project, that was the high wage rate. They were required to hold everybody to that same standard, and everybody had to pay their employees off of that standard. So that was essentially the way. In reality, the system is one of the things that a lot of contractors complained about, and especially not just the contractors, because to some extent it's a level playing field, but in reality, it allows the contractors with the really high wages, and again, whether they're union or non-union doesn't really matter, but the employers with the highest wages to be competitive on those public works projects. But what obviously the cities, counties, school districts, all over the state said, listen, I'm trying to build a new elementary school. And we could build this new elementary school for $5 million, and it would be a good quality school. And we've got plenty of well-qualified contractors willing to bid on it. And at normal, whatever their wage rates are, at $5 million, we could build it. But because of prevailing wage and having to pay the higher rates, it's going to cost us $7 million. And we can't afford to spend $7 million, so we're not going to build it. So all the counties, especially the smaller counties, the more rural counties, smaller towns, cities, school districts, on and on and on, have used, for a long time, needless to say, had a bad taste in their mouth about prevailing wage. Prevailing wage is going to, in my opinion, end up on the governor's desk. Unless there's something really weird happens between now and then, and God only knows in the last several months with politics, anything can happen. But prevailing wage, this prevailing wage, House Bill 104, simply repeals prevailing wage. Just simply, we're done. We're not going to do it anymore. We're not going to require you to pay anything more than state or federal minimum wage, whichever is higher. Now, they point out, which is obviously nice of them, to say contractors and subcontractors would be permitted to pay higher than the minimum wage if they choose, but that's not a requirement. All right, so you're not required as a contractor, just because you're building this school, building this bridge, building this road, building this building, to pay your employee a prevailing wage that was determined by folks in Jefferson City. Now, you can go on the Department of Labor and Industrial Relations website and look at wage rates for every county for multiple different construction type occupations, and you can get a real quick idea of whether or not you think those are inflated. All right, employment security. Again, we're going to put this on our website or email it to you so you don't have to write all this down unless you write real fast and you want to. But we start out at 20 weeks. It says right now, if you're unemployed, 20 weeks, that's it, your benefits are gone. However, if the unemployment rate is 9%, you get 20 weeks. As the unemployment rate goes down, your number of weeks expected duration of your unemployment benefits goes down. And these provisions take effect beginning January 1st of 2018. This is only for Missouri's unemployment rate. It is not tied to the federal unemployment rate, which we all know is different. And this is one of the very few pieces of legislation that comes out that is not effective on August 28th. It's effective on January of 2018. And as far as I know, there weren't really a whole lot of other things in this. There's a little bit. Specifically, the Act modifies the definition of wages for the purpose of employment security and to include termination pay and severance pay. I didn't realize they didn't already include that, but apparently they didn't, but they do now. Employer contributions discusses, which again just blows my mind. I had an employer overpay a self-insurance tax about 3 or 4 years ago, and even though they clearly overpaid it because the state gave them the wrong experience rating when calculating their tax, they still wouldn't send their money back to them. And I'm like, really? You got to be kidding me. Why can't we get it back? And I said, well, we'll let you credit it in the future, but we're not sending it back to you. Under this specifically says that if an employer overpays, they're allowed to get that back. If they overpay because the state makes a compensating error on their experience rating for unemployment insurance, not work comp, but unemployment, and they pay in too much, they can get that money back. It's unfortunate that we have to have rules that specifically says if you overpay, you get the money back, but that's the way it is. Contribution rates, and it goes into a little bit of detail here. If the trust fund is between 600 to 720, the rate is reduced by 7%. If it's between 7 and 20, I'm sorry, where'd we at? Must have left a word out. Under law, when the average amount is, oh yeah. Right now it says between 600 and 720, the rate is reduced. The new one says it's got to be between 720 and 870. Needless to say, all of the Division of Work Comp administrative charges the same way. The second injury fund charge is supposed to be this way. The unemployment rate is supposed to be the same way, to say that if our bank account in Jefferson City to pay unemployment and pay the employees of the Division of Work Comp and pay second injury fund claims, if we've got a big, huge balance here, then we're going to reduce your rate a little bit next year. That's just specifically stating that. All right, House Bill 289 on work comp. This is exactly similar to the same language in 113 that says on beginning January 1, 2018, which this specifically says that. I don't know that the other one specifically said January 1st of 18 on Senate Bill 113, but it says 40% interest in a corporation may elect to not have coverage. And last but not least, we have House Bill 460. House Bill 460. On a regular basis, we hear, usually politicians talk a lot. They're always got something to say. They're always being interviewed. They're always saying, oh, you know, we got this and this and this going on. Missouri is a judicial hellhole, and that's what they call it. I'm sorry, we live here. Missouri is supposed to be a judicial hellhole. St. Louis, in particular, apparently has been identified as such. And across the state line in Illinois, St. Charles and Madison County, Illinois are supposed to be really bad areas. And I never really took a whole lot out of that. I never really researched it, did much. I never said, well, what does that matter? What does it mean? I know we got some problems, but what does this judicial hellhole designation mean to us? It didn't feel good, but what does it really matter? Well, what I thought was interesting is, and I'm just going to give you a very general example, but this is probably an outlandish example, but it's what can happen. Let's say I had an employer last year. They were in Pennsylvania. They were involved in a large pile-up collision on the interstate during a snowstorm. They were driving one of their trucks. They were kind of in the middle. They weren't the ones in the beginning of it that caused all the problems. They weren't the guy at the end. So guess what? The guy in the beginning has got a problem. The guy at the end has got a problem. everybody in the middle is going to say, well, the guy at the end is the one that hit me. I was just sitting there. Somebody hit me from behind. All right, that's essentially the way it goes. Even with a 50-car pileup, at the end of the day, you're going to be blaming the guy in the beginning or the guy at the end. Everybody in the middle was innocent. Now, in that situation, that employer is based out of St. Louis. That employer is in St. Louis. His truck is registered to St. Louis. He wasn't really even at fault or involved. But now you've got an attorney that goes and says, well, I'm going to name all 50 drivers, all 50 automobiles, and I'm going to name all 50 people, and they're spread out all over the country. Most of them obviously were from Ohio, Pennsylvania area. A few of them are over-the-road truckers, on and on and on. Oh, wait, we got this one guy here and one truck and one driver and one registration in St. Louis, Missouri. That's the judicial hellhole. That's where we want to go take this claim. The reason they want to go take the claim there as a plaintiff's attorney is they want to go there because they expect to get a lot more money. They expect the courts to be more favorable toward the injured party, against the insurance carrier, against the employer, against everybody, and so forth. So we're looking at that thinking, well, why in the world is that claim being moved out of Ohio? I think it's Ohio. It may have been Pennsylvania, but they're moved out of one of those two states. Why is it being moved there to St. Louis when only one of those vehicles and one of those drivers, and that driver really wasn't even at fault? We're pretty sure he didn't cause it. We're pretty sure he really did get hit from behind and he didn't really do any damage to anybody. So why in the world, with nobody else in that entire lawsuit having any connection whatsoever to St. Louis, Missouri, why in the world are we moving that claim to the courts in St. Louis, to the state courts in St. Louis? Well, the problem is, as you can imagine, if you're a plaintiff's attorney, you want to go to the friendliest court. But as a state courts, what does that do to our state courts and our judges and our system in general? Well, the problem is it clogs our system to the point that we have folks coming from all over trying to file a claim in Missouri, specifically in St. Louis. And I read the legislation. This is one of the few bills I actually read word for word all the way through it. This is just a really, really brief summary that it appears to even identify whether or not people can move around county to county, venue to venue within Missouri, not just to Missouri, but even moving around within Missouri, saying, hey, I was injured in Christian County. I live in Dix, I live in Christian County. I know you people are, you put you on a jury trial, you're not going to be kind to me, you're going to screw me out of my money, so I'm going to take my claim to St. Louis. Well, this bill apparently even identifies that type of venue shopping. So with all of that said, this bill deals with that. The way this bill deals with that is simply says, if there are two or more plaintiffs in any civil action where there is a count alleging a tort, I love the word tort. A lot of people, what is a tort? We hear tort reform, tort legislation, we hear tort. A tort is just simply, I've been wronged, somebody hurt me, damaged me, I'm going to file a claim against them because they drove through my yard, they broke my ankle, they shot my dog, they burned my house down, they did something. That's a tort. Tort does not necessarily have to be criminal, though. That's important to keep in mind. But any civil action, any trial, any court action because of a tort may join in a single action only. And again, two or more plaintiffs. The example we were just using, we had 50 plaintiffs. They were all wanting to join in action because that one hapless guy, who's my client up in Ohio, driving along, minding his own business, he's in St. Louis. They want to bring this whole thing back to St. Louis. But they can only join in a single action only if each plaintiff could have separately filed an action in that venue independent of the claims of the other plaintiff or plaintiffs or whatever the case may be. So what this would say is if everybody wants to come back to St. Louis and file that big claim because we had that St. Louis driver involved in it, that nope, we can't do that. Only the people, 3, 4, 5 cars ahead of the guy, 3, 4, 5 cars behind the guy, yeah, they might have been able to convince a judge or jury that, yeah, that guy from St. Louis had something to do with my claim, and we're gonna take it off to St. Louis. But most of the people, so out of 50, maybe 3, 4, 5, 6 of them would have ended up being able to say, yeah, independently, I would be able to file in St. Louis, but the other 45 people have to go back to Texas or Oklahoma or Ohio, Pennsylvania, Massachusetts, wherever they're from, wherever they want to file that claim, they can't file it here in St. Louis because independently, they have no reason to use this venue. That's huge. That's huge. That's going to help a lot of things. Basically, it says if a claimant is deemed to be misjoined, basically saying they don't qualify for that venue, that he or she cannot establish proper venue, they are misjoined and they're going to be tossed out of this system. If proper venue cannot be established against a defendant individually, that defendant shall be deemed misjoined. So again, it could be the defendant or it could be the plaintiff. Either party could have a connection to St. Louis. If either party, but they've got to be they got to be related there. If a plaintiff or defendant is deemed misjoined, the plaintiff or defendant shall be severed from the action, and the claim shall be transferred to a county in which venue exists. That's, again, what tells me that that is even within Missouri. And then if no venue in Missouri exists, the claim shall be dismissed as a Missouri claim. It shall be dismissed without prejudice. Prejudice, what does that mean in the world of the courts? Without prejudice or with prejudice. With prejudice means we're dismissing this. We don't ever want to see you again. We're prejudiced to your claim. You can't refile this. You can't come back. We've turned you down. The judge said no. The jury said no. You just need to take it and go. However, what this says, without prejudice, basically says they can throw it out, but you can bring it back and try it again later. We'll throw it out. We're saying it's not fair. We don't belong here. You don't belong in St. Louis with your lawsuit, but that doesn't mean you can't bring it about. So saying it's without prejudice is probably a big thing to think that maybe later on down the road something might change and they might bring the claim back. All right, legislative resources, and this I think is my final page. Yes, it is. Legislative resources. I could overwhelm you with all the different websites and different things, and I could have overwhelmed you with the 166 House bills and the 30-something Senate bills and on and on and on, and literally we're talking thousands and thousands and thousands of pages of legislation. But with all that said, the easiest way, if you want to keep up with what's going on, is to simply go to governor.mo.gov, link to Governor Greitens' Facebook page. You'll get to see the pictures of his kids and Easter egg hunting and all that wonderful stuff. But if you go to governor.mo.gov, one of the prominent things on there, and I'm blown away by how little is on that web page. How little is on that web page. But you can apply for a board or commission if you want. You might be booted out by October 31st. You never know. It might be short-lived. But you can apply for a board or commission, but you can also see what has been sent to the governor's desk and what he signed and what he vetoed. And again, you can just say, oh, I don't care what happens in the House. I don't care what happens in the Senate. I just want to know what happens, what ends up on the governor's desk, and that'll show you what ends up on the governor's desk. That's all that's on there. That is all that will be shown on his page, and most of the time it'll tell you when he signed it or when he vetoed it. You are obviously always welcome to call me. Call me. Here's my office. You can email me. I'd be happy to help you out, send you copies, send you anything, give you updates, give you opinions, whatever you would like. Within the Department of Labor and Industrial Relations, it's labor.mo.gov. It used to be doler.mo.gov. As you can tell, I'm a little sensitive to that. But it used to be Doler, Department of Labor and Industrial Relations.mo.gov, but it's now labor.mo.gov. I suspect it may get switched back. But if you go to that website, it'll give you the Division of Work Comp, Division of Employment Security, Division of Labor Standards, and the Commission on Human Rights. It also has a link there to the Labor Commission, so you can theoretically keep up with what's going on, but I just got to tell you that they are extremely slow about updating that website. Very slow about that. And then last but not least, House and Senate. This is where I got all the information for today's presentation, was off of there. I simply go to there. I go to the perfected bills for the House, or you go to the Senate webpage and go to the perfected bills for the Senate, and you don't have to scroll through 1,300, but you're still going to have to scroll through a lot. It's going to give you one sentence saying, now this is what this bill covers, and goes from there. Do we have any questions, comments, concerns, any suggestions as far as what I think you should do as employers? Any at all? Okay. One of the things I would strongly encourage you to do, I don't think it's that big of a deal this year, to be frank with you. I think a lot of this legislation that's going to the governor's desk is legislation that has been vetoed in the past 2 to 3 years. A lot of this is the exact word for word same stuff. So that simply implies they're passing a lot of the same things that were vetoed. We're passing it again, and Governor Greitens is going to sign it. He stood by his promise to sign right to work. That was a huge issue. I think he's going to sign prevailing wage. That's a huge issue. I think he's going to sign probably most everything he gets here once it gets to him. Now, all that said, how much time do we have left for all this excitement, fun and excitement to happen? Let me pull this up and see real quick. As I mentioned earlier, Missouri is a part-time legislative state. The current session ends on Friday, May 12th at 6 o'clock. Friday, May 12th at 6 o'clock, which is exactly 4 weeks from today. So 4 weeks from today, anything up here we discussed is going to be passed, it's going to be done, it's going to be sitting on the governor's desk, ready to be signed. So 4 weeks from today, we're going to know where everything stands, whether it came out, whether it made it, whether it didn't. Now, a lot of this could change. It could change a little, add a word, take away a word, whatever the case may be. They'll probably start taking 4, 5, 6 similar bills, combining them all together and doing all that stuff. That will all start happening here in the last 4 weeks. The truth is, I expected a lot of it to start happening even in the last 2 weeks, and it just hasn't been happening. They haven't been condensing a lot of stuff down yet. But the last 4 weeks of the session are going to be absolute pandemonium. We can imagine Jeff City pandemonium. They're going to be doing a lot of things. They're going to be passing a lot. They're going to be working a lot of long hours and late hours and on and on and on. But all of this stuff will start pouring out of the House and Senate and heading over to the governor's desk within the next 4 weeks. And so what I would encourage you to do is simply, at bare minimum, if I had anything up there that you were especially fond of or angry about or happy about or whatever the case may be, if you go to the Missouri Gov website, the moga.mogov website, the very bottom one, and simply search for that bill, simply search for Senate Bill 43, SB 43, it'll take you right to that. It'll have the name of the legislator, it'll have the name of the rep or the name of the senator that sponsored the legislation, and on their website, you can literally click. For example, here you could literally click on Brown. It'll take you right to his website, right to an email. You could take 30 seconds to say, "Go, Senator Brown, keep up the great work, love your bill, I'm a strong supporter of it." Or you can say whatever you want. Whatever you want to say, you can say that. If you support it or if you don't, whatever the case may be. Actually, on that one probably doesn't make a difference because it's the only one signed into legislation. But that's what we got. All right, any questions whatsoever? Yes, in the back. Okay, the question was, let's say the unemployment rate goes down or up. How is that going to be implemented to impact any particular claim? Was it when they first began benefits or when their last day was and all that stuff? To be frank with you, I didn't read into the legislation to see that, but I'm assuming that if you entered your work comp claim, your unemployment claim first started on February 1st, that's the day you were first eligible for benefits, and the unemployment rate was this, your benefit weeks is going to be X number of weeks. They're not going to change that, in my opinion, throughout your claim. Is that kind of what you're asking, I hope? Okay. So that is probably going to be dependent on the day you first file or first become eligible for benefits. But I can look into that and find out for sure. I don't think it was addressed, to be honest with you, which, again, leads me back to exactly what I was saying earlier. This is a statute, and the statute's not going to have all the details. The statute would say this is what the legislature wants to do. They send it to the Department of Labor. The Department of Labor will have the Division of Employment Security. The Division of Employment Security will get together the referees and the Division of Employment Security's chief legal advisor, because all the divisions have a chief legal advisor, and then they will sit down and they will try to make all these little rules that help decide precisely how that's going to be implemented. But that's a good question. Probably something that'll be handled at the rule level, though.